class. All right, we're going to be starting a new chapter here today, Chapter 4, Lawyers and Ethics. And I don't know how, but I was able to get some excellent guest speakers to come in and speak with us this evening. I thought I had two. I got one right now. I got Joey Jackson. How many of you all watch CNN? Have you ever seen Mr. Jackson on CNN?
I have.
You have? No. Okay, well, that's all right. We're going to get to know Attorney Joey Jackson today. He's going to help us out in our discussion on Chapter 4. And before we go into this particular part of lawyers and ethics, or ethics and lawyers, we're going to stop first in the section that deals with the prosecutor. Mr. Joey Jackson, I believe, has some experience as a prosecutor, and so that's why I wanted him to speak to us about the prosecutor's role and how it relates to ethics, because sometimes, you probably don't think that ethics in some ways would relate to lawyers, but I'm going to show you in these sections that we're going to cover exactly how it does relate to the types of decisions that lawyers make. And a prosecutor, sometimes it's called the DA, the district attorney. That is the attorney that represents the state, the people in criminal cases against people. And we're going to talk about a case that is widely known. And before we begin, I'm going to give you a little bit of background if Mr. Jackson would please just give us a few minutes to get caught up on the story.
Absolutely.
And hopefully our next guest speaker, Danny Cevallos, will join us in the meantime. But today we're going to talk about the case, the Pennsylvania versus Bill Cosby. Yeah. You all know about that. And so here is a little background on that case, and then we're going to bring Mr. Joey Jackson in to give us his expertise on this case.
We start with breaking news, my exclusive story about comedian Bill Cosby and evidence that I believe jeopardizes the criminal case against him. You'll recall that just a few weeks ago, the famous comedian was finally hauled into court in suburban Philadelphia to face charges for sexually assaulting Temple University employee Andrea Constand. This after at least 50 different women, you see many of their faces here, all had come forward to say Bill Cosby had molested them. I have learned that this case, the only criminal charge that Cosby has ever faced, might soon fall apart. I have obtained a document that no other journalist has that could blow the case up. I talked about it a bit last night on AC 360, but now, new information. So let me back up and tell you the story. Back in 2005, the then district attorney of Montgomery County, Pennsylvania, Bruce Castor, was investigating Andrea Constand's case. Castor has said he wanted to prosecute Bill Cosby, but believed he did not have enough evidence to sustain criminal charges beyond a reasonable doubt. Still, he thought that Constand might get justice in a civil suit, and he claims he made an unusual deal to create an atmosphere where she could get that justice. The DA told the comedian's attorney, essentially, I won't prosecute your client if you promise that he'll testify fully in a civil case. Cosby's attorney allegedly agreed. It was a deal. In the deposition, Cosby admits he had sexual relationships with at least 5 women outside his marriage, gave prescription sedatives to women he wanted to have sex with, and tried to hide affairs from his wife. Cosby says he gave Constand 1.5 tablets of Benadryl, an over-the-counter antihistamine that can cause drowsiness, to relieve stress. He said that the sex and drug taking were always consensual. Why would Cosby testify so openly? Because allegedly he believed it would never be used against him in a criminal court. The civil case against Cosby was settled, and the deposition remained sealed for many years, but then last year a judge decided to release a transcript of it. And the explosive charges Cosby faces now are largely based on that transcript, which we now know could very well be thrown out of court when the case has a hearing on February 2nd. In the last few days, I obtained an email. This email that I confirmed was written by ex-DA Bruce Castor to his successor last year, 3 months before the charge against Cosby. Only those involved in the case have seen this email until now. It's the only clear record of the deal that was made promising not to prosecute Bill Cosby. And here's an excerpt. Castor wrote, "I can see no possibility that Cosby's deposition could be used in a state criminal case because I would have to testify as to what happened, and the deposition would be subject to suppression. I cannot believe any state court judge would allow that deposition into evidence. Knowing this, unless you can make out a case without that deposition and without anything the deposition led you to, I think Cosby would have an action against the county and maybe even against you personally." Bruce Castor has been subpoenaed to appear at the hearing on February 2nd, at which time I believe the case could fall apart.
So now I can go back to mine. So now, Joey, let me ask the class, was that clear as mud? What's going on, where we are now? Are there any questions on where we are now? So that I want you to be kind of having an idea of where we are, so that when Mr. Jackson comes in, you'll be up to speed. Yes, sir.
Just in order to make sure I understand the point. The reason in the first place he was brought up was because of what he said in that earlier case, which was then released, and that's why they're bringing up the charges on him. But because the deal was made that they couldn't use that, the case might be thrown out even to start with, because they shouldn't have been able to use that to prosecute.
Okay, yes.
Or to bring up charges.
Yes, you're right. So let's fill in the blanks. You're saying that there was a deal made. And who was that deal made by? Right, the prosecutor. And that's why we're talking about this. Because the prosecutor has made a decision in the beginning of this case back in 2005 not to charge Bill Cosby based on the information that he had at the time. All right. Now, Joey, talk to us.
Okay, can you hear me okay?
I can hear you better than myself. Okay.
Good evening, esteemed class. Hope everybody's well. So here's the point. I was a former prosecutor. Prosecutors have a vast amount of discretion. That is, they could decide to charge. They could decide not to charge. They can reduce charges. They can offer what are called plea bargains, which means they could lessen the degree to which they're charging a defendant in any case. Now, as to Cosby, what is significant here? What's significant is Cosby was under the belief that he was not going to be prosecuted. There was a commitment made between Cosby and his attorneys with the district attorney that he would not be prosecuted for any offenses involving the victim here, Andrea Constant. As a result of him believing that he would not be prosecuted, he went ahead and he gave testimony in a civil case. Now, let's back up 1 minute. Why would someone give testimony in a civil case? Well, because he was sued. There are a number of forms upon which you can go after someone. One is criminally, and that's the province of a district attorney. However, you don't need a district attorney if you're going to go after someone civilly for money. So in this particular case, Cosby allegedly did something wrong of a sexual nature to Andrea Constant. Because the prosecutor was not going to prosecute, she doesn't forfeit her right to sue him for monetary damages to try to collect money. Now, the impediment for going forward to trying to collect that money was deposing Cosby. What is a deposition? A deposition is when a person sits down and they're asked a variety of questions by attorneys concerning what happened, when it happened, how it happened, who was involved, who were the parties, etc. Cosby would not speak, however, if he knew he was being prosecuted. And so the story goes. The prosecutor said, listen, don't worry, I'm never going to prosecute you. Go ahead in the civil case and tell all you can to Andrea Constant's attorneys. Whatever you know, tell them. None of it is going to come back to bite you. Now, I know that you as a class know and are aware that a person has a right against self-incrimination. It's called pleading the fifth. When you plead the fifth, nothing you say can be used against you because you're not saying anything. So you're pleading the fifth. In this case, Cosby said everything. He gave a deposition where he told about his relationship with Andrea Constand, how many meetings he had with her, what he did with her, what he didn't do with her, the pills he gave her. He talked, okay? Now, the problem here, though, is that he talked relying upon the fact that he would never, ever, ever, ever be prosecuted. What happens? Fast forward years later, and now the district attorney is going after him, and a lot of what they're using against him is his testimony that he gave in the deposition. So he's saying, well, wait a second. I would not have said anything had I known that you would have come forward and gone against me after I talked. You promised me, Bruce Castor, that if I speak in a civil deposition, nothing I say can be used against me. Well, guess what? Years later, there's a new DA in town. And not only is there a new district attorney, but part of that district attorney's campaign promise was that I'm going to prosecute Cosby. If I get elected, he's going to be prosecuted for his abuses against women. Cosby says, well, I thought I was never going to be prosecuted. And if I was, I would have never said anything. The district attorney says, well, we never offered you any immunity. And Cosby says, you most certainly did offer me immunity. That's the only reason I gave testimony. So, curiously enough, in Bill Cosby's prosecution, much of what he said in that deposition is being used against him, which he would have never said had he ever had any inkling that years later, the stuff would have come back and haunted him. And so that's pretty much where we are now. And the legal fight is whether or not everything Cosby said in that deposition can be used or can't be used. Cosby said, I relied upon the prior DA who said I could talk day and night, and nothing I say will ever be used. The district attorney says, that's the old guy, I'm the new guy, and there is no written agreement to give you any immunity, and unless you produce a written agreement, we're prosecuting you and we're using everything you say against you. And that's pretty much where the fight is.
Now, Joey, let me ask you this. Well, let me just start here. Can we also add in the part that Cosby also thought the deposition was going to be sealed? Can you tell us about the piece that went on with the deposition and all of that?
Yes, that's a very good question that your professor raises, and here's why it's a great question. Because there are two layers. Number one, Cosby figured that nothing ever that he said in that deposition would ever be used against him. That's why he gave it, right? He would not have talked. And then the second piece was he was comfortable in speaking not only because he knew it would not be used against him, but because he knew the press would never get a hold of what he said because everything he said was sealed. That is, it was locked in a box and not able to come out for the press, not able to come out for attorneys, not able to come out for prosecutors, not able to come out for any purpose. When something is sealed, it's locked in a box, and only upon an unsealing order is it now unlocked and everyone gets to see what it says. So now we fast forward, and lo and behold, the deposition becomes unsealed. There was a motion to unseal the deposition. Cosby's lawyer said, how are you going to unseal it? This is something that's locked in a box, and you're not permitted to unseal it. The judge said, well, I'm going to unseal it because you have become a public moralist. You're talking about moral issues. You're talking about being holier than thou, but yet and still, you are engaged in this alleged abusive behavior. So I'm going to let the world see, since you're a public moralist, how immoral you really are. And so the judge unseals this, and since it's now unsealed, the prosecutor is now seeking to use that deposition testimony against him in his criminal case. And so the legal fight is whether a prosecutor can use a deposition that you've given in reliance on a promise not to be prosecuted to ultimately prosecute you, and you put yourself in jail by virtue of the admissions you made in that deposition to the other attorneys.
All right, I got a question. Wait, yes, ma'am.
Isn't there a specific term for that? Would that hold up in court? Because isn't that like fruit from the forbidden tree or something like that?
Okay. Did you hear that?
I didn't.
I want her to I want you to say that yourself, because I want you to hear what this up and coming lawyer question is. Yes, ma'am. She used a legal term of art.
So I was wondering if this would hold up in court Because wouldn't this fall under, isn't there a term like the fruit of the forbidden tree? So would this be able to hold up in court, or what's your take on it?
Can you hear? She said fruit of the poisonous tree.
Yes. Well, see, they're two separate doctrines, and let me just explain. I think ultimately, now we should understand that a judge has ruled that everything Cosby said in that deposition can indeed be used. And well, let's be clear. The judge ruled that they can still prosecute Cosby and use the deposition against Cosby. Okay. So far, that's where we are. However, I don't believe that that's going to carry the day. I think the only reason Cosby spoke was because he relied upon a commitment. He relied upon a promise. He relied upon the word of the DA that nothing he said could be used. So I think what a judge, if I'm the judge in this case, I rule you can prosecute Cosby, but you cannot use anything he said in that deposition to prosecute him with. Now, fruit of the poisonous tree, of course, as we know, is a doctrine wherein anything that was illegally obtained, right? So I understand where your very brilliant student is going with this.
That was real good.
Yes. Anything that was illegally obtained cannot be used ultimately because it's poison. It's the fruit of the poisonous tree. So it's very similar to that, I would argue. Very similar to the whole fruit of the poisonous tree doctrine, where, for example, you're using something that was illegally obtained to now bury and prosecute someone against their will. And so the fruit of poisonous tree is a different concept, but it's very analogous, and it's very astutely pointed out that it has some application here.
Okay. I have another question. Yes, sir.
So I would imagine that I think this is probably going to have an unintended backlash, because if the previous DA makes a deal and this new DA is saying, well, that doesn't matter, that was previous DA, doesn't that basically undermine the entire authority that the DA has if his promises can't be upheld if he's no longer there?
Can you hear that?
That's a wonderful question. Let me say this. Your class is brilliant. Let me say this. What the now DA is saying is that you did not, former DA, bind the Commonwealth of Pennsylvania. And the reason you did not bind the Commonwealth of Pennsylvania is because you did not get it in writing. And he's saying two things. The new DA, to be clear, is saying two things. Number one, I'm not undermining your authority because you didn't get it in writing. And in order for an immunity agreement to be effective, it needs to be in writing. And number two, the new DA is saying a district attorney can't offer immunity. Only a court can offer immunity. And since a judge never offered immunity, there was never any immunity. And so therefore, I'm proceeding with the prosecution. And so I'm not undermining your authority because you had no authority to bind the Commonwealth, and you had nothing in writing which does bind the Commonwealth. And so therefore, that's what the new DA is relying upon to do what he's doing, which is to prosecute Cosby on the strength of Cosby's own testimony in a deposition.
Okay. Yes, sir. I got a follow-up.
One thing I would imagine, at least, is at least during the interaction between the original DA and Bill Cosby, all those interactions and deals made were for him under the good faith of the authority of the DA. So would that kind of have, I mean, isn't there some kind of umbrella of good faith between when you're talking to someone of authority like a DA and he tells you something, so you're in good faith recognizing and believing that he has the authority to do it?
Well, give us a wrinkle on that.
Exactly. Listen, that is a very astute observation, and I'm going to tell you how astute it is. There's a doctrine of law called detrimental reliance. And what that means is when you rely in good faith upon something someone told you, right? If you rely upon it to your detriment, meaning you're hurt by it, now it cannot be used against you, because that's the exact argument here. Cosby's saying, I relied in good faith upon the former DA telling me, whether it was in writing or not, whether he had the authority or not, I don't know. I just know he said, give a deposition. Anything you say will never be used. Go ahead, have at it. And now, and I rely upon you in good faith, now you come back to bury me with what you told me would never bury me. And so the law calls that detrimental reliance. And whenever you rely in good faith upon a representation made by someone in authority, and that representation that's made to you in good faith comes back to harm you, you can say, since I relied upon it, it cannot be used. And that's one of the arguments that Cosby's making. And that's one of the arguments that an appellate court may very well use to rule that Cosby's deposition cannot be used against him.
Now, I haven't even gotten to my questions yet, because I want to try to, because there's so many wrinkles in this case. Now, what about the piece where, you know how when a party is usually represented by their attorney, and these representations were made to an attorney that Cosby had that is no longer with us.
Right.
Talk about that, please.
Well, the fact is unfortunately, Cosby's lawyer at the time, who was engaged in these discussions, is dead. But who's very much alive is the former district attorney. And the former district attorney, Bruce Castor, went to court and he testified in a hearing and he said, hey, I told Cosby I would never use this against him. I issued a press release saying we're going to dismiss the case. And as a matter of fact, what I did was, because I wanted Andrea Constand to have some measure of justice. Now, understand that our system is imperfect. What it does to pay or compensate victims of many things, injuries, sexual abuse, you name it, is to give them money. Now, money is insufficient when your dignity is taken away, but that's what our system has to deal with you. So what the prior DA, Bruce Castor, said was, since we won't prosecute her criminally, maybe she can get a measure of relief in civil court and go after him for money, right? He wasn't opining as to whether that was satisfactory or would ultimately deal with the underlying abuses or the humiliation or what have you. He just said, I can't prove it criminally. I, however, am going to make this agreement with Cosby so that you can go and get your money from him in the event he's held to have done something wrong. And the only way you can get money from him is if he participates in the process. So I'm going to allow him to participate by saying, say everything, tell her everything, when, where, how, who, what, and I'm never going to use it against him. And ultimately, that's exactly what Castor did. Allow Andrea Constand to sue him civilly by allowing Cosby to give a deposition and to talk, and thereby forfeit his Fifth Amendment right against self-incrimination. And that's what happened here.
Okay, now, before I get back to you, Joey, I want to clear up this piece about the deposition transcript. Was there not a FOIA motion to release some court documents that had excerpts from the deposition that have been unsealed, or has the entire deposition, I'm talking about a certified copy of that deposition that would hold up in a criminal trial, has that been ordered released?
My understanding is there were portions of the vast majority of that deposition is out. There were portions of the deposition that have been made public, and those portions are so damning and damaging as to constitute the deposition itself. Meaning, on the critical issues in depositions, there are a lot of things that your class should be aware of that are asked of you. Where do you work? How long have you worked there? What do you do? How long have you done it? How many children do you have? Where do they go to school? What are their names? Those are, those are issues that relate to who you are, but they're not critical issues relating to the liability of what you're doing. And in this particular case, critical issues relating to the liability of Cosby vis-a-vis his relationship with Andrea Constand, when he met her, how he met her, what he did with her, what, if any, pills he gave her, how many pills he gave her, what he did to her when he gave her those pills, all that is out. So while there may be portions of the deposition that we haven't seen, I would argue that those issues relate to issues that we're not really concerned about. What we are concerned about is very much public, and that's at the core of what prosecutors want to use against Cosby to prosecute him.
Okay, now hold on, Joey. I'm going to say something that I said in this class before that's gotten me in trouble. But if you're the prosecutor, I'm going to let you be the prosecutor, and I'm going to be the defense lawyer. I'm going to say to you, that's all well and fine, Mr. Prosecutor. However, that's hearsay until you can get a proved up copy of that transcript. Tell me where I'm wrong in that. Thank you.
Well, here's the problem. The problem is that an admission by a defendant operates as the exception to the hearsay rule. And so to the extent that a person makes an admission against themselves, that's plainly admissible in court. And any admission that a defendant gives, for example, a defendant in a case tells their friend, I was with Andrea Constant. Tell somebody else, I did X, Y, and Z to Andrea Constant. Tell somebody else, I gave Andrea Constant pills. Tell somebody else, I was abusing her. All of that is an out-of-court statement. Yes, it is. However, to the extent that it's an admission, it comes in as an exception to hearsay. So technically, you know, while you might suggest that it's an out-of-court statement used to prove the truth of the matter asserted, since it's an admission being made by the defendant, the court is going to accept that as reliable and therefore admit it into evidence.
But Joey, it's not proved up. It's just something that's out there on TMZ now. It's not the actual one that the court reporter, that they go over to Veritex and get a certified copy of that document. To me, until you have that, because the person themselves, the declarant, is not going to testify, that document is hearsay.
I understand what you're saying, and it's a very good point you make. I think the retort to that point is that it becomes, number one, you know, look, you're right, to the extent that if there's a certified copy that you swore to under oath, that's the best evidence. And if you don't have that, I could wiggle out of it and say, hey, I never said that. But if you have a TMZ or some other type of undocumented, unsworn statement, and in court they use it against Cosby, it becomes a credibility question because he'll be confronted with it. And they'll say, hey, Cosby, didn't you tell TMZ that you knew Andrea Constant, that you were with Andrea Constant? Didn't you tell the New York Times, A, B, and C? If he admits or denies it, it's going to be up to the jury to assess his credibility as to whether he's lying or being truthful. So yes, a certified copy of any document sworn to out of oath is the best evidence. And if you don't have that, it's troubling. But you still could be confronted with some other type of thing that you said. And if you deny it, it becomes up to the jury to say you're either being credible or you're lying.
Okay. So you think it comes in even if it's not a proved up copy of that transcript?
I think if he testifies...
He's not going to testify now.
If he doesn't testify?
He's not going to testify. You think he's going to testify?
I think he's got to explain. Well, here's my issue. Here's my issue. I think
after this deposition debacle, trust me when I tell you, if Bill Cosby is my client, he will never utter another word in the wake of day. I'm just saying.
It's a very good point, and it'll be up to his attorneys. But look, he's saying an awful lot by not testifying because of the depositions, and they may be things that he may have to explain. And a jury is going to want to hear from him. And so we'll see whether his attorneys put him on or they don't. Remember, he's now blind, he's frail, he's older.
Yes, all of that. I would have him in there on a walker. Just hobbling in. Okay, I'm sorry. I have some questions. George, how much time? I mean, can you give me about 5 or 10 more minutes? Okay, let me get back here first. Yes, sir.
First of all, big fan of Mr. Jackson.
We got a fan.
When he met with the lawyers in privacy, was his lawyer present with him, or was it just the victim's lawyers?
He wouldn't have been present at the meetings that would have taken place wherein the promises would have been made for him, for the charges to be, for him to give up his right against self-incrimination, to go ahead and testify in the civil case. He wouldn't have been present. It would have just been his lawyers, right? Don't you agree with that, Joey?
Generally, his lawyers would deal with that and they would convey that information. But, you know, is it possible that there was some meeting where he was with the prosecutor and his attorneys and they said, Mr. Cosby, we're not going to move forward against you, but, you know, there's going to be a civil case and I'm going to tell you can testify? That could have happened. I mean, we don't know. But generally, lawyers take care of the legal issues regarding, you know, what's admitted, what's not. Whether you can testify, whether you can't, whether there's going to be agreement to prosecute, whether there's not going to be. That's pretty much a legal issue that would be handled by attorneys.
Okay. Yes, sir. I have a question.
2 questions kind of interconnected. One being that I'm assuming the civil case was settled, and which way it was settled, can criminal charges be brought afterward, after a civil case was settled, basically?
See, now since Danny's here, I can let Danny address these issues, and
You gotta go to it.
I cede my time to Cevallos.
Okay. All right. Okay. All right. Well, thank you so much. I appreciate you so much. Look.
Anytime.
It's a complete standing ovation round of applause. All right, Danny, you ready?
Peace, love, and happiness. All right. Good seeing you guys.
All right, bye-bye.
See you guys.
Get out of here, Joey.
Take care.
Get out of here. Take that tie off. You never take that tie off, sir.
Be good, buddy.
Take care,
Enjoy.
Thank you. I really appreciate it.
Take care. Bye-bye.
Bye-bye.
And now, folks, for the less talented portion of your show, Joey Jackson. Now you're stuck with Danny Cevallos.
Hey, Danny, you're the second shift.
I am the second shift, I see, yes.
All right, let me tell you where we picked up and where we left off, okay?
Okay.
Joey was explaining to us about the deposition transcript in the civil case.
Yes.
Now,
Which case are we talking about here now?
we're talking about the Bill Cosby case. It's still on.
Yes, of course, yes.
Okay. And we're still talking about the agreement that Castor entered into with Bill Cosby. We were kind of dabbling over whether or not that deposition transcript, not the deposition transcript, this is what I want to back up on. Is the deposition transcript ordered released, or was it excerpts from the deposition transcript that was in some motions and in that court proceeding? So
I am almost certain at this point that it's the latter, the second of the two, which makes this really interesting if you're a civil attorney and you practice law. Yeah. Okay, so the motion, somebody filed a motion, and in the body of that motion, and I don't know how familiar the students are with motions, but a motion is just a written request with the court, and in that written request, you often include exhibits. So a lot of people believe that the deposition transcript was just released, and that really wasn't the case. What happened was one of the litigants filed a motion, a written request, and in support of that motion, it's not unusual to cite portions of a deposition transcript. And the reason you do that is because a judge is human. They don't want to be paging through 100 pages of deposition transcripts. You want to give them the highlights. I do it all the time.
But I'll never do it again.
Yeah, I will never do it again, because the scary thing about this case is that it gives an attorney so much power to take something that is otherwise sealed and not to be released,
Right.
to just quote it. And just by quoting it, created this entire case against him, an entire criminal case, just by quoting a few paragraphs in the written portion of a motion without even attaching it as exhibits. And you see attorneys do this all the time. They cite portions of some written document because they know what everybody else knows and what your students know and what I know. I have a short attention span. I don't like to read 500 pages of documents. Just give me the bullet points. But when you do that, you might be using the bullet points from a sealed deposition.
So hold on, let me just make sure that we're all up to speed on this piece.
Why can't I see the students? I want to make sure they're not on Facebook and what's going on here?
Oh wait, hold on. I'm sorry.
I don't trust them, Dana.
I'm sorry, hold on. I forgot that the meeting ended.
There they are.
Sorry about that.
Thanks for the wave. I see you.
All right. There we are. Okay. So I need to bring everybody up to speed on this. In the civil case, so what happens is we have the criminal case where the attorney, the prosecutor says, I'm not going to charge you, Bill Cosby. Go ahead. We want to help the lady to get her settlement, her money from the civil case. And so in the civil case, at some point, there's a deposition. And so Bill Cosby's probably not acting right. So it causes that attorney to have to file a motion. Am I kind of?
Yes.
Yeah, it causes the attorney to have to file a motion. He's not acting right in the deposition. And so the attorney wants to describe to the judge, he's trying to get Bill Cosby to testify about something or whatever. We don't know. So
That's correct, yeah.
So he goes into that motion and he writes out exactly what happened in the deposition from the transcript that he gets from the court reporter. He goes and he looks at it, he said, oh, Bill Cosby said this, I said that. Bill Cosby said this, I said that. And he's complaining to the judge about something. That now is in the court, but everybody agreed that that deposition would be sealed.
Right.
Now, however, this attorney on the other side has filed this motion and has put excerpts from the deposition into the motion. Go ahead.
Yeah, the written part of the motion, right.
Go ahead. Yes.
Right. It would be like if I wanted to ask the judge and tell the judge something about a Harry Potter book, and instead I just said, hey, it's in the book, and attached as an exhibit the actual Harry Potter book, and said, Judge, now you read this whole thing and you figure out what I'm asking for. Instead, this person read the deposition transcript and took his, I believe it was a female attorney, took her greatest hits, her favorite sentences. Again, as attorneys, this is something we do all the time. But when you take it from something that's sealed, that really raises the question. Something that's sealed by the court means no one else is supposed to see it. And as attorneys, we're often charged with these secretive documents, and it can be really scary to be the safeguard of those documents. And here's a lawyer who just took something that was helpful to her motion, but ultimately had incredible other consequences, because anytime you file something, it's public. Anyone can look at it. And one thing you should know is that reporters are often trolling through, I say trolling not as a negative word, but that's what reporters do. There are people who are assigned to the filings at the courthouse. Those are public documents. The reality is the only reason that we don't discover more scandalous stuff is that it's boring to look through court documents. But if you have the wherewithal, if you have the lack of ADD and you can do it, you can find out some really scandalous things. And that's exactly what happened here.
So fast forward all these years now, all of these allegations are coming forward. And who was it? Was it TMZ? Who was it that filed the motion with the court to unseal these documents?
I think it was one of those. I think it was one of those outlets. They filed it. So a motion to unseal. The thing you have to understand is courts are supposed to be public. So the natural state of affairs, just like the natural state of a ball that you drop is to fall to the ground. The natural state for courts is for documents to be public. They don't like things to be sealed. So they do so reluctantly. And then what happens is that they have to have a good reason to keep them sealed. And of course, what we've learned over the years is that the media, even though they may not be a party to an action, sometimes has an interest in having these documents unsealed. When you combine that with the fact that courts hate sealing documents to begin with, I'm somebody who seals documents on a regular basis. And believe me, courts do not like to do it willy-nilly. They like to do it only for a good reason. And there are very good reasons to seal documents. But the important thing to know, and this was a big issue in the Cosby case, one of the main reasons to seal documents is not because it's incredibly damaging to someone's reputation. That's not a good reason. There's a famous line from the movie Liar, Liar, where the attorney objects and the judge says, why? And he says, it's incredibly damaging to my case, Your Honor. And it's a jokey line, it's a throwaway line, but it's exactly, you can't get a document sealed just because it's incredibly sensitive and damaging or embarrassing.
So why were these sealed then?
In this case, they were able to get it done. I mean, for whatever reason, they were able to convince a judge that this involves information that's incredibly damaging enough to meet the high bar for sealing documents. But as a general rule, just because something's embarrassing, you're not going to get it sealed.
Okay, I have a question. Yes, sir.
There are quite a few different women that have come forward with their accusations, and quite a few years past. How many are actually going to be involved in a prosecution forum with charges being brought up? Because I would imagine that some, if not quite a few, have been past the statute of limitations, unless,
okay.
Yeah, I would have to assume the statute of limitations for these crimes, because I believe that only murder is the only thing that didn't have the limitations.
Yeah, I can answer. You want me to answer that, or do you want to take that?
I do want you to answer it. Okay. Well, I want you to answer it because it relates to this case. And
Right.
bring it in and let us know what all happened surrounding the statute of limitations in this case.
Okay. So, as you know, first, the statute of limitations, we're all familiar. In Pennsylvania, it's 12 years. This case was filed months before the statute expired. And the statute of limitations, all that is our government draws an arbitrary line in the sand. We say, look, after a certain period of time, evidence is stale. People forget things. Witnesses are unreliable. So the same evidence in 1985 that would be valuable, no matter what, is inadmissible 20 years later, or whatever the arbitrary number is, the line in the sand, because people forget, witnesses disappear, and at some point it becomes fundamentally unfair for somebody to have to come into court. But what makes that so odd is that it's not a case-by-case analysis. These laws are just arbitrary. Somebody picked 12 years. There's no reason it can't be 10 years. There's no reason. Some people argue that there should be no statute of limitations for sexual assault. So, and I believe some states don't have them, and I think Texas might be one of them, but I'm not sure. But there are, so anyway, that's what the statute of limitations is. And for the most part, because these cases are all so old, this is one of the only cases that was not only recent enough as an assault, but the statute of limitations was long enough that they were able to file charges. So this may be one of the only criminal cases that you will see against Bill Cosby, because all of these alleged assaults happened over sometimes 2 decades ago, but at least a decade ago. So the question was, do you want me to address the other accusers and what role they would play?
Well, let's stay on this one and talk about when she talked to the first time that she brought these allegations.
Right.
Yes. Back in
the first time, right. So a lot of people say, well, hey, wait a minute. She didn't report. She reported a little late, but certainly she reported this within the statute. Let's say, just for argument's sake, the accuser reported this incident a year later, right? You all know now the statute of limitations is 12 years. So 1 year later is well within the 12-year statute of limitations. There shouldn't have been a problem with the statute of limitations at that time. So the prosecution, or what would have happened is that the detectives, the special victims unit detectives, would have interviewed her. And for whatever reason, remember, sex crimes are very, very unique. They're not like a murder where you usually have a body, although I've had a no-body murder case. But a body gives you a tremendous amount of evidence. On the other hand, in sex cases, it's often he said, she said. So it's an entirely different kind of body of evidence. And I say body figuratively. But in the OJ and OJ Simpson case, you had 2 bodies that provided an unprecedented amount of DNA and other evidence and blood evidence. On the other hand, in a sex case, it's often, especially if it's a year later, you're not going to have a rape kit. So it's literally somebody going on the stand and saying, this is what this person did, and it's a credibility determination. So they interviewed her, and they not only interviewed her, but another witness would have been her mother, who spoke to Bill Cosby on the phone. She obviously wasn't there when this happened, but if Bill Cosby made admissions to her, while that's typically what we call hearsay, and that doesn't come in to a trial, if somebody admits something, then that is an exception to the hearsay rule. If you've watched enough TV, you've heard someone shout, objection, hearsay. Well, there are a lot of exceptions to that rule, and one of them is when you make an admission. I'll give you an example. A lot of lawyers will tell you, if you ever get in a car accident, the first thing you don't do is get out and say, oh my God, I'm sorry, I'm sorry, I'm sorry. Don't do that, because some courts might construe that as an admission. Instead, ask, is everybody okay? Can I call the police? So anyway, you had those 2 witnesses, and for whatever reason back then, the DA decided not to prosecute. Why does the DA think there's any difference now between what the evidence they had then and the evidence they have now? Well, the DA's position is, and I don't want to speak for the DA, but this is what it sounds like, is that there's new evidence. What is that new evidence? The new evidence is that little excerpt from a motion that quoted a deposition where Bill Cosby says, I used preludes and I used them during sexual encounters. And I'm paraphrasing because I can't remember exactly what it says. But in the DA's view, that admission of using drugs satisfies almost proves another element of the statute in Pennsylvania, which says that anyone who has sex, and to achieve that uses drugs is guilty of a crime. So in the DA's view, the new evidence that they had that they didn't have a decade ago was that he admitted that he used drugs and used drugs in the course of having sex. He didn't necessarily say with her. He didn't necessarily say that he slipped them to her without a permission. But that's new evidence. And in the and if you haven't, I mean, I'm a defense attorney, everyone, so sort of take everything I say with a grain of salt. But you can see how a DA would say, well, that's something new. He didn't exactly say I did it, but he's saying he used drugs. That's new evidence. Now we think we can charge him with this new evidence. And do the math. If it's 11 years later and the statute of limitations is 12 years, he's still within the statute of limitations. So that's how you get to these charges. And the statute of limitations can be a very controversial thing because you really are picking just a number out of your hat and saying, this is, after this time, you can't charge somebody with this crime. And it's strange because if it's something like just a simple assault, a bar fight, that statute of limitations might be 2 years. And by the way, if you get hit by a car in a civil case, those statutes of limitations are much shorter. In Pennsylvania, you have 2 years. In New York, you have 3 years. And if you get run over by a UPS truck and you don't sue within 4 years, you're out of luck. And a lot of people say statute of limitations, the acronym is SOL, and I don't know if that's an acronym you're also familiar with, and I won't say it in class, but
thank you.
It has an appropriate, it has sort of that's what lawyers say to each other. If it's statute of limitations and you file too late, that's SOL. That's what it's called.
Okay, I have some questions. Yes, ma'am.
So a little bit off topic, but I have been able to really concentrate since you said it. Can we go into further detail on the no body murder?
She wanted, you talked about the fact that you have a murder case, but they can't find the body. She wants to talk about it.
Well, this is and this case I already had. It was a couple years ago. I've also practiced in the U.S. Virgin Islands in an island called St. Croix. And the U.S. Virgin Islands are a territory. They're part of the United States, but for our purposes, you can think of them just like a state. They have local laws, they have federal law, just like any other state. But so I have a lot of thoughts on no body murder cases. And does anyone here remember about 5 or 6 years ago? It's the Casey Anthony case. Everyone, show of hands. Who remembers Casey Anthony?
Oh yeah, we did find something, but we never really found the body, did we?
No, you did. Well, what happened was that case was originally charged as a no body murder case.
Yeah, that's true.
Sometime later, after they had charged her, then they found the body.
Yes.
And I've always said that, strangely enough, the case got better for Casey Anthony after they found the body. Why is that? Well, let me try this test on you, everybody in the class. Suppose these are the only facts you know. Child is left with mother. Child disappears. Child's gone. Who do you blame? The mother, right? You don't have any other information. On the other hand, now you find a body and the defense was able to raise all these other inferences, whether you believe she did it or not. The defense now had all this new evidence that they could point to. Hey, there's duct tape. Hey, there's this. Hey, there's that. That means there was an abductor or something else. And I would argue, and there's no way of proving it, that once they found the body, the case got weaker for the prosecution because there's more evidence that the defense can exploit. Sometimes having less is stronger for the prosecution. Now, the no body cases, they are very, very rare. As you can imagine, in modern times with technology and everything else, it's very difficult to make a body poof, vanish. It doesn't happen very often. But I got one of those cases where it was a similar case where a person had gone missing for 10 years, and they finally charged my client 10 years later. Now, everybody here, maybe you've heard, does anybody know what the statute of limitations generally is for murder?
No statute limit.
There's none. Yeah, there generally is none. And the idea behind that, back in the time of the framers, the idea was that if you kill someone, you should always be looking over your shoulder, wondering when the police are coming, no matter what, no matter how bad the evidence is. So a no-body murder case, it always raises the defense that you can argue that, wait, you haven't proven the case because this guy could walk in the door tomorrow. You have no idea where he is. But our courts have said that you can prove circumstantial evidence of somebody's death. And in this case, it was a witness who said they had seen the killing take place. Now, that is enough in our body of law in the United States, although it's a tricky business because, well, that one person had a lot of power, that witness. And how credible is that person? And so I handled that case, and it did not go our way. All our clients were convicted, and the case is on appeal. But it raised an issue. I mean, this entire murder case, they had no DNA, no nothing. It came down to one person getting on the stand and pointing out our clients and saying, those are the guys that did it 10 years ago. So it was a really, so the point is that no body murder cases are rare. You can probably count them on, they're probably a few dozen a year. But when they happen, I would argue that they're very strong cases for the prosecution, because the prosecution can just sort of raise all kinds of negative inferences, and there's really not a lot the defense can do. They're very tough cases to win when they happen.
Okay. All right. Hold on. Yes, ma'am.
I just had a question about the relationship from the witness testimony to the mother.
Okay.
The relationship with, we're talking about Cosby again.
No. I'm sorry. This no body murder, for the relationship to the witness that said that they saw what took place.
Okay. So, all right. So this was, I'll give you, if you're interested in the facts of this case were this, and it was very bad for us because this was no ordinary person that vanished. It was a cop that disappeared a decade ago. Now the cop, there was evidence that the cop had gotten into some sort of some monkey business, but again, it was evidence that was 10 years old. There wasn't email or cell phones or anything like that we had any evidence of. So this guy vanishes, and the story that emerges is that we'll just say a female with a criminal past who was the mother of one of the defendant's children. And I'll say that's about it. So she was not happy with one of the defendants. And so we exploited that and pointed out her bias. But for this jury, our clients admittedly didn't have the best reputations in the community. So, and neither did she, but I guess it washed out, and they found her credible. But she was the mother of one of the defendant's children, and they had a real tumultuous relationship. And it's one of those cases that to this day, we may never know what exactly happened, but those guys were convicted, and their cases are on appeal.
I'm going to come back to you. Let me get, yes, sir.
I guess my question is, how could you use someone with a checkered past with a criminal record as a credible witness? That she was the only witness you have that you could use, or?
Well, let me say, I mean, I'm a defense attorney. I didn't use that witness, but the prosecution does this all the time. And I don't want to sound like I'm going after the prosecution, but this is a very common practice, because the reality is criminals are not hanging out with people like you in this classroom. All of you that I'm looking at, you guys, your buddies are not drug smugglers. Crooks hang out with other crooks. It makes sense. But one of the other massive tools, especially in the federal government's pocket, is the use of confidential informants, and this is their MO. You take a typical drug ring. You go to a lower level drug dealer. You approach him. You say you're looking at 50 years in prison. All you have to do is testify against this guy above you that you see once a month to make your pickup. It's that or 50 years in prison. What are you going to do? And what would you do? You think about your family and your loved ones. And if somebody came and made that kind of demand, no matter what your level of guilt is, I hate to think that if somebody, FBI came to my door and said, you're looking at 50 years, will you testify against the bad guy? I wonder what I would do. I mean, I don't like the idea. I've been to a lot of prisons. I don't like going there at all. So you ask, why would the prosecutors use criminals?
But Danny, you have to realize this is a criminal justice. This is not a law class. So see, you got to bring it into the courtroom and make it basic. The fact of the matter is, can you stop? Would the judge say that this person cannot testify? That's the question.
No. I mean, the qualifications for a witness are to be qualified to speak as a witness. All you have to do is understand the words that are coming out of the attorney's mouth and be willing to swear, take an oath or an affirmation. And beyond that, almost anyone can testify. But the next question is, are they believable? So prosecutors roll the dice when they call these witnesses.
And who is that left up to, whether or not they're believable?
Right, exactly. So if you're going to call a criminal to testify,
No, I'm really
you have to
asking
weigh
you
it
to
out.
answer that. I'm really asking you to answer that question for the class. Who
What's
is that up to? Whether they believe them? Who? The jury, right?
Well, the jury, right? It comes
Right.
down to, do you believe him? I mean,
Right.
because that guy's going to come up there and say something bad about the defendant, and the first thing the defense attorney is going to do is point out what a corrupt person this is, and that they have a deal with the prosecutors that will avoid jail time. So it becomes a credibility problem, but prosecutors have to weigh that decision every time. They say, hey, I have Johnny Criminal here. The defense attorney is going to tear him up, but he's also willing to say that Douglas defendant shot the guy in the library with the revolver. And you have to weigh that out. How believable is this person? And the same thing happens, if you go back, in sexual assault cases. Sadly, you know, it's a really tough business for prosecutors. They have to weigh out whether they think the story is credible or not. They have to weigh all that out before they go to trial, because if you have somebody that's completely not credible, the prosecutor knows the case is in trouble. But the last person who prohibits a witness from testifying is usually the judge, because the rules say, as long as you know how to take an oath, and as long as you understand what's going on in the courtroom, and you understand the difference between a lie and the truth, these are very basic requirements. A court's going to let almost anybody testify. The real question is, if you're a prosecutor or a defense attorney, you're calling a witness, what does that witness give you, and what are the potential downsides? How completely unbelievable are they? And if they are, then you just ruined your own case. It's a risk you have to take.
Because that jury is the judges is gonna leave it up to the jury to take in that information and go back there and decide on whether or not they believe that witness was credible. Now, you were just talking about agreements. Now, is that a part, whether or not the prosecutor entered into some type of agreement with this person, would the jury have an opportunity to hear that?
Oh yeah, that's one of the first things that you should point out. If you have Johnny Criminal testifying against the defendant to say, yeah, we dealt drugs all the time. I got my drugs from him. He gave me a great deal I mean, I swear you can't make this up. I once had the government using one of these drug dealers, and he said on the stand, you know, my drugs are the best on the entire island. He boasted about it. What did he care? I mean, he was getting a deal. So you point out that deal. You say, you know, you ask questions. You say, well, you know, here today, you're not here today for your health, are you? No, I'm not. You don't want to be here today, do you? No, I don't. In fact, the only reason you're testifying is because the government gave you this sweet deal. Yes, it is. And what is that deal? Well, I'm going to avoid this much time, and this is what I'm going to get. And, you know, you don't want to be in prison, right? No, I don't. And you love your family, right? Yes, I do. And you'd do anything for them, wouldn't you? Oh, yes, I would. You know, would you die for them? Yes, I would. Would you lie for them? And then they get sort of paused. They're like, no, I wouldn't. Well, you'd die for them, but you wouldn't lie for them, and that's an old sort of cross-examination trick.
And
But,
so the prosecutor will bring that witness, and then you'll get a chance to bring out all of this unsavory information, and then the jury gets a chance to go in the back and say whether or not they believe what that person said.
Yes, and just as sort of an epilogue, in my personal experience, and this is just my personal experience, I find that no matter how culpable or unbelievable a witness is, if they are a criminal too, I find that if a guy, no matter how wacky a guy is, if he gets up there on that stand and points out your client, my personal experience is a jury will disregard a lot of credibility problems, and they'll tend to believe somebody who comes in and points the finger at your guy. That's just my experience. Other people might have a different one, but I think that's been my opinion.
No, I agree with you on that. Yes, sir. I have another question. Yes.
Anyway, to bring it kind of back around to the
Yes.
case.
Yes.
From my understanding, the testimony he gave, in which he did admit into giving drugs, was either both consensual, or in another case, or in a case where it was for a headache or some such.
Okay. So is it the testimony that of Bill Cosby, would he say that Miss Constant had a headache and that's why he gave her the sedative?
He might. I don't know that he said that in the deposition transcript, but would he? I think he said that either in the. I don't remember. I know that's come out, but if he did, that's going to be his defense. If he's going to use that as a defense, if he testifies, which I don't know that he would testify.
I don't think he'll testify.
I mean, we all, as defense attorneys, we always say our client wants to testify, but that's not necessarily saying that he or she will. So, I mean, that kind of defense, you have to think about it. Who's the only person that can testify about that? It's going to be Bill Cosby. So the jury may never hear about that. She had a headache and I wanted to give her a Benadryl or something like that. Because arguably the only person who can ever testify to that is Bill Cosby. But then you have to ask yourself, if I put my guy up there, that opens the door and you can hear the dump truck backing up, beep, 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 right up as that prosecutor gets to ask him anything in the world that he wants to.
Right. Yeah, I don't think he gets on the stand myself. Now, my question to you is, would you ever, based on this ironclad agreement, if it were going to be so, would you ever advise a client to do this, what Bill Cosby did in the civil case? Testify.
Go testify. This is the single wackiest, the thing about the law in general and in criminal defense, no matter what, every day brings a new wacky story. And this agreement, if it could be called that, and the judge concluded there was no agreement, did not follow the typical way that you have an agreement with the prosecution. And first, on one hand, the idea that a prosecutor, I think of all the prosecutors I work with, the idea that they would ever care that somebody who's a complainant, who's a victim, would be able to sue a defendant. Right? These are very separate worlds. Prosecutors don't care one bit about the civil side of law. They're in the business of prosecuting, and that's all they do. So the idea that this prosecutor, Bruce Castor, would have been worried about whether or not Constan would get money out of Bill Cosby seems insane to me. But for whatever reason, he said, hey, if you go testify, we don't think we have quite enough. We think it's a close call. We think we could almost prosecute you, but maybe not. So if you go testify against her and give deposition testimony and she can sue you, if you willingly do that, because you all remember, he doesn't have to appear for a deposition and give any testimony that could incriminate him. That's the Fifth Amendment. So if you give up your Fifth Amendment privilege and go testify, I won't prosecute you. That's the arrangement. People enter into wacky agreements like this all the time, but this is one of the wackier ones because usually the agreement is, hey, I'll plead to a lesser charge, but you'll also get a guilty plea out of me. That's your typical plea agreement. But in this case, he did something very unusual, which is go testify in the civil case and we won't prosecute you. But nobody wrote it down. Nobody took a pen and wrote this down. So now we're left arguing about whether or not there was actually an agreement. But as a defense attorney, it's easy for me to say I would never, ever, ever counsel somebody to go give a deposition. And I think 95% of me today says it's a crazy thing to do. But I've also 5% of me says I've been in situations where your client wants nothing more than the prosecution to go away for any reason whatsoever. And I think if the prosecutor had said, well, if you dress up as a clown and run down Main Street, we'll withdraw the charges. I know clients that would have done something silly like that. So 95% of me says this was insane. And frankly, I mean, why would, taking off my lawyer hat for a minute, I'm amazed that Bill didn't just lie. I should never tell anyone to do that ever, ever, ever. And I would never tell a client to do that. But it's amazing that he got to this deposition and you'd think he would try to cover himself. But my view is, I think he didn't think I don't know what he thought. He thought it wasn't a big deal or whatever the case was. But it's amazing. I mean, like I said, you're under oath. You got to tell the truth. But I'm sure his lawyers were thinking, they probably had no idea what he was going to testify to. So, the final verdict is he should not have gone to that deposition, even if it meant they were going to prosecute him. But again, that's a tough decision to make.
Okay, so let me ask you this. So that 5% of you, wouldn't that bring that within the purview of some type of ethical concerns from a defense lawyer standpoint to make sure that that is completely explained to that person?
Well, yeah. Well, the thing that makes this problematic, and like I said, 95% of me says this is a bad deal. But then there's that 5% of me that says, your client wants the case to go away, and if that'll make it go away, maybe that's what he wanted to do. But from there, if you have an agreement, it's important to get it down in writing for exactly this reason. And for whatever reason, the attorneys, maybe it was a different time. It wasn't that long ago. It was 10 years ago. That's not that long ago. But maybe these lawyers just thought, hey, this is a gentleman's agreement. And that's just an old phrase. It could be a gentleperson's agreement, whatever. But maybe we just have a deal that's just a handshake deal. And we'll never have to see you. We'll never see you again. You'll never hear from me again. Just go give your deposition. And that way justice will be done because you'll be sued and lose some money. Now that sort of sounds like it just to a lawyer, that sounds like a crazy deal. But at the time, I guess they thought it made sense. But the real problem came later because nobody got it in writing. Nobody ever made an arrangement. Nobody ever typed anything up and had the parties sign it. Maybe because each side knew how crazy this deal was.
And so bringing it, fast forwarding to today, Bruce Castor gets on the stand and he testifies that the press release that he made, to him, was the written agreement. Speak to that.
Yes. So because they didn't have an agreement in writing, that left the defense had a really powerful witness in the actual DA who made the agreement, who got on the stand and said, I made this agreement. And prior DAs can bind later DAs just because they're not in office anymore. But he got this press release and he uses it to say, okay, here's the writing that confirms or backs up my testimony that there was an agreement, even though that agreement wasn't formally in writing. But that's a real problem because this is why we say get everything in writing. And I should add that for the most part, whenever you have a plea deal and you go before a judge, although this didn't go before a judge, you say the terms of the deal on the record and you have someone typing everything down and putting it into a transcript that you can order, and that's like a deposition transcript almost. So the idea that this was never memorialized other than in some press release and some other documents is just not the same. There's a big difference between a piece of paper that's a press release and a piece of paper that's a legal contract. They're totally different. I mean, we're talking about the difference between the wrapper that wrapped the food that you bought today and your actual credit card receipt. I mean, the wrapper is proof you bought the food, but the best proof of the transaction is that credit card receipt that you signed and that you have in your pocket.
Okay. So to tie this all up then, the prosecutor, there were not really big ethical concerns in his decision not to charge Bill Cosby back then, because he could put a lot together to say, okay, she comes a year later and makes this claim. At that time, some people are making a big deal about the piece that she already had a civil attorney. That's not a big piece for me.
No.
But then also, you will find yourself having to have a criminal trial against Heathcliff Huxtable. That's a concern. So there are a lot of concerns that would make that prosecutor, that would make this a case that's not really triable. You didn't have the evidence that he needs. He had his investigators to go out there. He had all that he needed. It was just all of this other stuff really leaves a bad taste in the mouth when it comes to, because for me, I'm gonna tell you what I think. I think there's something fishy going on here.
Oh yeah. Why? Yeah, absolutely. Oh, one thing.
How could he do this?
Yeah, I think it's very problematic. By the way, I'm noticing there's only about 3 minutes left on the timer.
Okay.
I don't know if you need to
All right. Yeah.
No, not for me. I'm happy to do it.
No. I gotta let him go. So.
Okay. So I'll say this. I mean, about what I think is crazy is, I mean, you end up charging Bill, Cliff Huxtable, but at the same time, if you're the prosecutor, you realize most of the people who remember who Cliff Huxtable is, they may not be on the jury because that's a show from I guarantee not one of you saw the original Cosby Show unless it was in reruns, right?
None of these people
reruns.
on the jury.
I see you back there. Reruns. Get out of here. That was 1983.
Right.
So there's that, and then also he's gotten such massive bad publicity that most people have already formed an opinion about him. I mean, he's had the worst for the last year, so he may be a very easy defendant to prosecute because the old rule of thumb is very good on everything.
But back then it was a different case. He was Mr. Huxtable back then. Now, if members of the jury are here today, he could probably be found guilty.
Oh yeah, because everyone in this classroom, most of what they know about Bill Cosby is not Dr. Huxtable. It's guy who's been accused over the last year of some really bad stuff. So I think the Bill Cosby we knew growing up is not something that this jury is going to think about, unless you get some people my age and older.
Okay. All right. Okay, well, this has been too short. I really do appreciate it. We appreciate it, and we want to say thank you so much.
Thank you. Listen, I'm very insecure. I need to know I was better than Joey Jackson. Now, I know that guy. He's a lot smoother than me. All right. Thank you. Guy in the way back. Yeah, he had a tie. I know. I understand. Yeah, I'm very jealous of Joey Jackson. I have to tell you right now. Right.
Okay, Daddy, I really do appreciate it. Thank you so much. Okay.
Thank you for having me. Good night, everybody.
All right. Good night. Bye-bye.